Good evening, friends. Welcome to today's Manthan, which we are now having outside under the tree after a gap. Fortunately, the rains have let up. We have today two speakers who have come to Hyderabad especially for this. The subject is reforming of district courts. And you know, we have a lot of discussion, opinions about what's happening in the higher courts, but not the district courts. And as you will hear today, there are a lot of challenges over there, and there's a lot to be done as well. The speakers are Prashant Reddy and Chitrakshi Jain. Prashant Reddy is, both are trained lawyers, but I think neither is a practicing lawyer as of now. Prashant Reddy did his law at NLSUI Bangalore, and then in Stanford, and then he's worked in Singapore in law firms, academia, and he's also written two other books. One on copyright, it's called Copy Cut, and it's yeah, and another on, it's called The Truth Pill, both co-authored books. Chitrakshi is also a lawyer. She did her law here in Nalsar. And then, interestingly, she went to JNU and did her MPhil in political science. And has worked in civil society organizations and is now working in Trustbridge Foundation. Am I correct? Yeah. So she's basically working in the not-for-profit sector on issues relating to the law. So both of them will speak about their new book, which is also available for sale, which if you would like to pick it up after the talk. Prashant, Chitrakshi, please.
Thank you everyone for coming here, and thank you to the organizers of Manthan for having us, to discuss our book. I'm very grateful. Our book, which is titled Tareekh Pe Justice, Reforms for India's District Courts. And the title, because we realized that a lot of younger people weren't getting why we named it Tareekh Pe Justice. I'm sure the older ones amongst you know about you heard of the famous dialogue of Sunny Deol in Damini, where he screams out at the court when the judge is granting another adjournment, saying कि हमें सिर्फ तारीख पे तारीख मिल रहा है, my lord, इंसाफ नहीं मिल रहा है. And that dialogue has become so iconic that it has crept into into policy documents, into judgments of the courts. Every time a person is frustrated with the legal system and its failure to deliver justice in a timely manner, this dialogue has made its way into that particular document. So that's why we chose the name of the book. Now let me get into the subject of the book. I'm sure all of you can't see this, but just to give you some context, the Indian judicial system is a three-tier system. You've got the Supreme Court at the top, then you've got the high courts, which are the highest courts within the state, and then you have the district courts. The district courts are a three-tier system. For example, you have a district judge, you have a civil judge, senior division, civil judge, junior division, and then on the criminal, these here only civil cases, and then on the criminal side, you have the sessions judge, the chief judicial magistrate, and the magistrate, judicial magistrate first class. Now, the district judiciary is the first point of contact for most litigants in the country because these courts are present literally in every district. They deal with the largest load of litigation in the country. Like most of your cases will not even reach the high court. All your property disputes, contract enforcement, matrimonial cases, bail cases, they all start at before the district judiciary. And crucially, the judicial magistrate first class, although he's at the bottom of the hierarchy, is perhaps the most important person when it comes to protecting your civil rights and civil liberties. Because when a person is arrested, he has to be presented before the judicial magistrate within 24 hours. And the judicial magistrate then has to decide whether to give the state remand of this person or let him out. So this is, and apart obviously from criminal cases where they're deciding the life and liberty of people on a daily basis. So this level of the judiciary, despite its importance to our daily lives, actually gets very little attention. Whether it's in mainstream media or even within legal academia, there are very few people actually studying it. When we were researching for this book, we found maybe about one or two other academics who were looking at some of the issues pertaining to the district judiciary. So our book is focused entirely on this layer of the judiciary. We're not looking at the high courts and the Supreme Court. So now let me begin with the argument that we're trying to make in the book. Now, traditionally, any kind of conversation that we have on the district judiciary and its failure to deliver justice, it's always been framed in terms of lack of resources. That is, you hear Supreme Court judges, High Court judges talk, they say, oh, we don't have enough judges for the district judiciary and we don't have enough funds. Now, our argument is that this actually isn't the problem. For example, what matters actually is what is the methodology that you're using to calculate the number of judges. For the last 20 years, the Supreme Court has been using this methodology where they're trying to calculate the number of judges by pegging it to the total population, by pegging it to per million people in the country. And they continue to do this despite their own expert reports. These are expert reports commissioned by the Supreme Court. There's a law commission report which has said that population should not be the metric as per which you calculate the number of judges required. Because if you just take, for example, the city of Delhi, which has 20 million people, and you take Bihar, the state of Bihar, which has 100 million people, civil litigation rates are higher in Delhi than in Bihar, which is because of the fact that litigation and caseload before courts is not guided only by population, but by wealth of the society, by the other economic factors. What is the economic activity happening in a particular society? So these are all factors that contribute to the volume of litigation that is taking place. So Supreme Court, successive Supreme Court judges who continue to cite this metric of judges per population without understanding that their own reports have completely discarded this method. So the right way perhaps to calculate the number of judges is looking at the caseload that is there before the courts. The problem here now is, despite having spent about 2,500 crores to build the National Judicial Data Grid and the digitization program for district courts, we still don't have accurate data. I'm not getting into the details of this, but the only good news is that this 5 crore figure that you hear in the media of pending cases before the district courts is likely very exaggerated, because there's a problem with how cases are being counted by this National Judicial Data Grid. And our estimate is that the cases are actually far less than that. The larger problem, however, is the inability of the judiciary, especially the Supreme Court, to inculcate a culture of transparency within the judiciary, because statistics is all about transparency, right? And it's tragic that when we were researching for this book, we found better statistics from 1879 in the Madras Presidency, because the British state was doing a much better job of collecting judicial statistics than we can find for in India in the last 10 years. So we don't have, because we don't know the number of cases pending, it's actually difficult to calculate whether we are actually running short of judges or not. But on pure statistics, like I said, the statistical fact is that the number of judges in India has increased almost threefold at the district court level. So in 1987, we had about 7,675 judges. Now we have about 21,000 judges. Another 4,000 posts are vacant. So it has tripled. And in addition, judicial capacity has increased, because what the government has done is they've created debt recovery tribunals, for example, which has shifted a lot of litigation that banks used to have before district courts to these specialized tribunals. So in that sense, judicial capacity has increased. So there has been a political willingness to hire more judges, create more capacity. And we have also seen Parliament pump in funds over the last 20 years. About 10,000 crores for judicial infrastructure, 2,500 crores for digital infrastructure. So all this money is going in, resources are increasing, but nothing is changing on the ground. And we are trying to explore other reasons as to why perhaps this may be happening, and why there has been no substantial change in the pace of cases and the speed of disposal before the district courts. And one of the issues that we want to look at specifically is the issue of judicial independence. Now, traditionally, when we talk about judicial independence, we are looking at it from the perspective of the Supreme Court and High Court and how independent that they are from the executive arm of government. But there is another aspect of judicial independence, which is what we refer to as decisional independence. That is a judge confident enough of delivering a judgment without having to fear consequences for his career after doing so. Now, the district courts, since independence, have come under the control of the high courts. So this was specifically requested for during the consultation process over the draft constitution, because the draft constitution, when Dr. Ambedkar submitted it to the Constituent Assembly, did not have any provisions on the district courts. So there were judges who had requested that the district courts be specifically placed under the control of high court judges, because during colonial rule there was a tendency of the provincial government ministers to interfere with transfers and postings of the district judiciary, and that they felt was impeding the independence of the district judiciary. So the Constituent Assembly shifted the control of the district courts completely to the high courts. So in that sense, they insulated the district courts completely from executive interference. That is, a minister cannot change the posting or promotion or transfer of a judge of the district judiciary. But does that by itself ensure that the district court judges are independent? Because at the end of the day, there are high court judges who still wield a significant amount of power over these district court judges using three levers. One is disciplinary inquiries, which I'll be talking about. The second are performance assessment tools and transfers, which my co-author Chitrakshi will be talking about. So let me start off with explaining how the disciplinary mechanism works. So unlike the high court judges or Supreme Court judges, where you have a system of impeachment by Parliament, I mean, we're probably going to see an impeachment proceeding very soon in the next few months, wherein the entire process is conducted in public. You have MPs moving a motion for impeachment, which is made public. The inquiry committee report that follows the impeachment motion is also made public. The judge's defense against that motion, he will be given a chance to address Parliament and give his side of the case. Even that will be televised on television. And the final debate before the vote on impeachment will also be will be broadcast on television. So the entire process, when it comes to the High Court and Supreme Court judges, is in the public eye, and it's very rigorous. When it comes to the district judiciary, however, the entire process is in-house. It's controlled by High Court judges and an official called the Registrar Vigilance, who's basically a district judge on deputation to the High Court. So for a couple of years, he'll stop sitting in a courtroom. He'll be given this position of Registrar Vigilance, where he's going to be screening complaints received from various quarters. And we are still not sure how the process actually works to initiate a complaint despite filing RTI applications, because high courts have treated the RTI Act with quite a lot of contempt. But we do know that at some point an inquiry officer is appointed by the High Court, who's generally another judge. This inquiry officer conducts a fact-finding mission to where both the High Court's prosecution attorney and the judge under investigation are given a chance to present their viewpoints, cross-examine witnesses, etc. A report then is submitted to a disciplinary committee of the High Court consisting of maybe between 3 to 5 High Court judges. These High Court judges then make a recommendation to the full court of the High Court, that is all judges of the High Court, and the judges of the High Court then have to decide whether to accept this recommendation or to reject it. If they accept it, it's communicated to the state government, and then the state government is bound by the recommendation of the High Court. Now, there are several problems with this process. One problem is that it is clouded in secrecy. So we have filed RTI applications for the purposes of this book, and we aren't able to get even basic information. Even the inquiry committee report, after the judge has been dismissed, even that is not made public. And if any of you know how the Indian state functions, the moment there is this much secrecy over functioning of a crucial aspect of the state, things tend to start going wrong. The second problem that I'm going to highlight over here is the manner in which these disciplinary inquiries are being conducted, especially for the legal reasoning offered by the judge. So generally with, High Court and Supreme Court judges, they get the law wrong all the time. We see judges, Supreme Court now recalling their judgments quite frequently, but there's never any move in Parliament to impeach these judges, because there is a consensus in the political class that judges may get things wrong at some point of time. That's no reason to impeach them from their job. But that's not the case with district courts. And I'll give you a couple of examples of how this is playing out. So this was a disciplinary inquiry against a lady judge in Uttar Pradesh, Judge Sadhna Chowdhury, where they started an inquiry against her basically for granting generous compensation in the land acquisition case. So the curious part of this case is neither neither party to the suit, that is the government or the property owner, complained about her judgment. The case was an appeal before the Allahabad High Court. One of the judges hearing the case thought that there was something fishy, and hence they started a disciplinary inquiry against her. And this is a charge that was framed against her. I'm not going to read it verbatim. I'll just tell you what it means. So they start off with saying that, okay, you have decided this land acquisition case. You have decided it illegally and against all judicial norms and propriety by awarding a certain amount which was more than the amount granted in some other land acquisition case. And hence, it leads to an inference that you are actuated by extraneous considerations and you thereby fail to maintain absolute integrity and complete devotion to duty, and thus committed misconduct within the meaning of the UP Government Service Conduct Rules. So what this basically means is they're saying, you granted this much compensation, which we think was unfair, hence we are presuming that you received some kind of bribe or extraneous consideration, and now you defend yourself against this charge. Now, it is logically impossible to defend yourself against the second part, right? Because they have not told you what bribe you received, who you received it from, when you received it. So, most of the times, judges who face charges like this, they then have to they end up defending the legal reasoning in their case, trying to say that, no, the reasoning that I offered in this judgment was actually accurate, and there's no problem with that particular reasoning. Now, this is actually the job of an appellate court. Like all litigation in India, you have at least one right to appeal, and it's the appellate court's job to decide whether a judgment has been rendered as per the law or not. But with district courts, we have seen a trend where judges are being put on trial for their judgment and they lose their jobs. So Judge Sadhna Chowdhury, she lost her job. She had to litigate for 14 years. 12 years before the Allahabad High Court and 2 years before the Supreme Court before she got her job back. Now, just imagine the state of mind within the UP Judicial Service when they know that this is how disciplinary inquiries are being conducted against their peers. It creates a climate of fear, which then means that judges aren't able to render fair and decisive justice. It also gives them a reason to avoid cases which they think are particularly risky. So this is another case involving a district judge, Krishna Prasad Verma. So there were two charges against him. One was for granting bail after a High Court judge had rejected bail. The second charge was this, where they basically said that while you were the district and sessions judge in Chapra, with an intent to acquit a person accused in an NDPS case, you closed proceedings in great haste, resulting in the acquittal of the person who was charged with carrying about 90 kilos of charas, without exhausting all coercive means to record the statement of the investigating officer. And as a result, this act of yours is indicative of some extraneous considerations which tantamount to gross judicial impropriety, blah, 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 blah. So, let me explain what this charge means again. They're basically saying that you let a particular person off, you acquitted him without a trial because the investigating officer didn't turn up, and you didn't use all possible coercive means to ensure that the investigating officer was produced before you. Now, the fact that is not recorded in this particular charge is the fact that the investigating officer didn't turn up on 18 occasions, and there is no police officer who's going to arrest another police officer and bring him to court as a witness. So if a litigant is suffering in these kind of circumstances, the judge actually did the right thing by acquitting the gentleman and saying that, I'm not going to conduct, actually discharging and not conducting a criminal trial. So in this case, again, Judge Verma was found liable, and he was imposed a minor penalty on him, which is basically he was suspended. He lost his pay without suspension for some time. Plus, he was withheld from promotions for a span of 3 years. Again, he had to litigate his case all the way to the Supreme Court, and he won after 10 years. And this is for granting bail and acquitting a person and trying to protect his liberty when clearly the investigating officer was not showing any seriousness in prosecuting this case. So the bail issue specifically, we didn't have the exact charge. So because we weren't given access to inquiry committee reports, we had to depend on judgments where judges had challenged their, the punishment given to them to try and cull out some of these charges that we're presenting to you here. So we don't have the exact wording of the charge on his denial of bail, but this is one of our hypotheses, which appears to be substantiated now even by some High Court judges, is that because bail is a particular magnet for disciplinary inquiries, because bail is a highly discretionary remedy, and High Courts over the last 20 years, we've seen a trend for sure in terms of judgments, in the last 20 years have been initiating disciplinary inquiries left, right and center over the grant of bail by the district judiciary. We have not seen a single disciplinary inquiry for not granting bail. It's always for granting bail. The assumption is that there has been some bribery involved, which is why we are seeing this great bail crisis where a majority of bail applications now are going to the High Court and the Supreme Court. In the last year of Justice Chandrachud's term as the Chief Justice of the Supreme Court, he narrated in an interview that the Supreme Court had decided 21,000 bail applications, because that is the degree of fear that has crept into the district judiciary. And he's a judge who in fact has been saying for the last few years that there is a climate of fear within the district judiciary, but he does not explain where that climate of fear is coming from. Because to an ordinary listener, they think that perhaps the judge is afraid of the government, but no. They are actually afraid of their own peers within the judiciary, and that is generally the Registrar Vigilance and the High Court judges. So I want to read this. So this is basically where they initiated an investigation where it says that you clearly show that the manner and mode in which you awarded the sentence in a particular criminal case clearly shows that the accused has managed with you for showing favor in awarding sentence, and accordingly you awarded the punishment, fixing the term of sentence in such a way that the accused need not have to remain in custody for any longer period. And hence we presume that you've indulged in a corrupt practice. So again, the facts in this case were the judge didn't follow a minimum sentencing requirement in the law. So under customs law, there's a specific punishment of certain number of years that have to be granted to people caught smuggling certain items. In this case, the judge basically said that whatever time you have served, that's sufficient. I'm not granting the minimum sentence prescribed in the law, and this is very common. I've seen this happen with the pharma industry multiple times. The law says minimum 1 year you have to go to jail if you manufacture substandard medicine. And you see number of cases where judges award simple imprisonment till the rising of the court. So it's not a big deal not following a minimum sentencing requirement, and this could also have been rectified on appeal. But this and another charge, which we don't have here, were cited to dismiss the judge from his job. He lost his job because he was lenient in sentencing, and there was no corruption in this case or the previous case. There was no evidence of actually money having exchanged hands, because the way the charges are written in these disciplinary inquiries is that we are presuming you are corrupt because your legal reasoning is flawed, this is an insane standard to follow anywhere. No other country does this. Like in the UK and the United States, judges have blanket immunity for the substance of their judgment, because it is presumed that an appellate court is going to correct this particular issue. Now, what happens when there are allegations of corruption? If you can just... Right, so this was a case where the judge here has directly been charged with the receipt of illegal gratification. The facts in this case are particularly gruesome because There was this involved a person who was accused of murder and rape and murder of a minor girl. So the person had been arrested, he was in jail. This particular judge granted that person bail, but after the charge sheet had been filed. So the law is very clear that once a charge sheet has been filed, and there's no possibility of tampering with the evidence, and as long as certain conditions are imposed on the accused, which this judge did, he made sure that the person had to present himself before court at least twice a day, before the police station twice a day. Those conditions were imposed. But after he granted bail, there were some rumors floating around in the village, which the deceased girl's father heard. That is, apparently a bribe had been granted to the judge in order to grant bail. So they charged the judge, they started a disciplinary inquiry, they found against him, and they dismissed him, despite the fact that they actually had no evidence of a bribe being paid. And we know this because when the judge challenged his dismissal before the Madras High Court, the Madras High Court in its judgment has, in one sentence, they say that, yes, there is no direct evidence of a bribe being paid in this particular case, but, it's difficult getting evidence in these kind of cases, so we're just going to believe whatever hearsay evidence is there. And that's the problem. And even when there are charges framed specifically on you have received a bribe, the evidentiary standards are so unclear. For example, in a regular civil or criminal proceeding, the Evidence Act is very clear that hearsay evidence will not be allowed. That is second-hand evidence. That I heard from somebody that this happened. That is inadmissible evidence in a regular judicial proceeding. But because these are administrative proceedings, high courts have said that, the Evidence Act doesn't apply. We can admit hearsay statements, and on the basis of which judges end up losing their jobs. And despite it being blatantly unfair, you don't have to be a lawyer to understand that hearsay evidence is not reliable evidence. The most common kind of corruption cases that we came across when we were researching for the book are cases involving middlemen or allegations of middlemen. Now, this is a very common, if you're a practicing lawyer, you keep hearing these rumors of this judge has this middleman, you pay him a bribe, he will manage your stuff. Now, no one really knows whether this middleman is actually passing on the bribe, whether he's authorized by the judge to collect a bribe on his behalf. But we've seen a number of disciplinary cases where a judge is charged with soliciting a bribe through a middleman, but neither the middleman nor the bribe are produced during the disciplinary proceedings, and the disciplinary inquiry is also not able to show any connection between this middleman and the judge. So there are a lot of times there could be cases where there are litigants, who are unhappy with the judge, and they can end up fabricating complaints saying that, oh yes, this man solicited a bribe on the behalf of the judge. And we have seen multiple cases of judges losing their jobs, despite the inquiry committee not being able to produce the judge, the middleman, the money, the supposed bribe that is received, nothing. So when you're operating in this atmosphere of complete fear, judges will react as any sane individual would in these circumstances. If you're holding a salaried job until your retirement, you will try and avoid risky cases which have powerful litigants. Or number two, you will just avoid granting certain risky remedies. And bail has become one of those risky remedies. Because of which these days you ask any lawyer practicing, your first bail petition will almost always be rejected. Right? So this is how judges then react to some of this, and it's very, very easy for them to avoid risky cases because of the transfer system. You know that within, say, 3 years, I will be shifted out of this place, or within 1 year, my docket will be rotated. So it's very easy, and then the end effect of the system is you have got judges who are fearful of doing justice as per the book because of a system which they don't have complete faith in that it will protect them from false allegations and frivolous complaints. My co-author will take over for the remaining issue.
Thanks, Prashant. The other ways in which the district judiciary is also assessed is through, they have regular performance assessments. So there is an annual confidential report that is prepared for each judge where they are subjected to an assessment which is based on their character, their integrity, and most importantly, each high court has devised a unit system which is primarily a quantitative weightage given to each task that is supposed to be performed by each judge. So, for example, if you go to the next slide, if a judge is examining a certain number of witnesses, for each witness, they get a certain point. So, they earn units in discharge of their judicial functions and even for administrative tasks. And the unit system methodology, which is prescribed by each high court, also mandates that each judge, depending on the cadre, has to attain a certain number of units to get certain ratings, which are average, below average, good. So they will have a time period in mind. So either this unit assessment is done quarterly or annually, and they need to then show that they have in fact earned these number of units which are prescribed in the unit system methodology by each high court. Now there are certain drawbacks with having such an approach, which forms the basis of their annual confidential reports and the ratings that they get in these performance assessment mechanisms. It's quite easy for the judge to game this system and make sure that the easier to hear cases are then decided so that that judge earns the required number of units to get a good rating. So the way it translates into action is that there are cases which are more, which are lengthier, which involve more witnesses, are probably heavily contested, and the tendency of the judges then is to make sure that they dispose of the easier cases first, get their ratings, and get the required rating in the ACR, which is good, to get their career progression on time. Yeah, so they have these ratings where you get a certain number of units, you will either be awarded poor, below average, average, or good, and they need to get a good rating, and this affects their promotions not only in the near term, but also in the long term. And why? The first drawback, of course, is that it makes sure that all the heavily contested and more difficult to hear cases are pushed into the background. The other drawback of such a system is that these ratings that these judges earn during their annual performance reviews are then used to compulsorily retire them when they have attained certain milestone ages. Now, the district judges are subjected to this very particular administrative practice of compulsory retirement, which is in fact, in terms of time, is a relatively recent introduction. It was introduced through a Supreme Court judgment in a litigation by the All India Judges Association cases, where the Supreme Court directed and formed a Shetty Commission, which looked into the service conditions of judges and then later prescribed that there is a need to separate the judges which are not very competent. And this mandatory review is then conducted at certain milestone ages of 50, 55, and 58. In Gujarat, for example, as soon as a judge turns 50, they would be then subject to a mandatory performance review, in which any adverse remark which is present in the ACR can then be used to justify their order of compulsory retirement. Now, why this is particularly problematic is that when the High Court issues such an order, it is not bound to give any specific reasons for why it is compulsory retiring a judge. The order just mentions that this is done in public interest. So there is no requirement on the High Court to in fact justify. This is a very subjective assessment. Any adverse remark or a pending disciplinary complaint against a judge is used against the assessee judge, and then the judge is compulsory retired. It's very important to remember here that security of tenure is a very important facet of judicial independence. So there are other ways, of course they should be free to write their decisions, but security of tenure gives them the confidence to write these decisions very freely. And these are certain administrative practices which make the job of the judge very insecure, because as soon as when the judge is aware that they will be subjected to this mandatory performance review, they will obviously be incentivized to not hear the risky cases in any manner that may seem unfavorable to the high courts, etc. So what we have managed to do is that we have ensured that the district judiciary is completely safeguarded from interference from the executive in the way the constitution and the laws are written, but they do not have sufficient safeguard from the way the high court administers control over them. So their independence is still compromised, not really from the executive, but by the administrative practices of the high courts, through which they are judged regularly through these performance-based systems. And you might think that this compulsory retirement is a one-off instant. the high courts don't really proactively publish this data anywhere, but sometimes when there are episodes of mass firings, for example, high courts when they compulsorily retire judges en masse, maybe they've fired more than 10 or 12 judges, newspapers pick it up, and from that information we were able to gather that between 2009 and 2024, some 94 judges have been compulsorily retired only within 5 high courts. So the actual practice of compulsory retirement is more endemic in high courts than you would think. It's quite common that these judges are then subjected to these performance reviews at these milestone ages and then compulsorily retired. So this is one way in which their performance they are sort of made vulnerable, and judges who are closer to these milestone ages become more vulnerable. There's another class of judges which is also particularly insecure, which are probationers, and these units are also applied to them. They need to earn the required number of units, and if their disposal is not up to the mark, they again can be fired. They cannot be confirmed into the service. Again, no justification is given to them. There are no reasons in writing required for these probationers who are not then confirmed into judicial service. So these are two classes of judges, judges who have had at least a decade in judicial service, who are the judges who are attaining these milestone ages, and newly inducted judges who are on probation for sometimes unspecified periods of time, who are also made particularly vulnerable through this unit system. Now, this unit system has to be seen in combination with other administrative practices which are common in state judiciary, which is that these judges are also transferred regularly. So not only are they transferred inter-district, their roster and their portfolios also change very frequently within the same district. And now what this leads to, again, is the same problem, where the judges, when they are aware of the fact that there is a successor who will then decide those cases that were previously assigned to her, they have a tendency to make sure again that the more complicated cases are never decided during their tenure, because they know that they will eventually be transferred out of that district or their portfolio will change. So the commitment to that caseload that they were initially assigned is very low. Now, this problem is not new. Robert Moog, who is a scholar who's written on law and society, he did his ethnography in courts in Uttar Pradesh, had written about this problem, and his argument was that judges in India are in fact the only temporary player in this legal ecosystem. So the bar is entrenched and so is the court staff, and the judge is the temporary player, so they have very little incentive in fact to correct all the administrative inefficiencies in that courtroom, because they are quite vulnerable. The bar is local, so is the court staff, and they can easily gang up against the judge and make sure that they are, and we have seen instances where, when especially it is also influenced by gender, where a lady judge has tried to correct some administrative inefficiencies in the court staff and has seen retaliation in the form of vigilance complaints. So this is not just a hypothesis. The judges are made very vulnerable by the practice of transfers. And it would make sense if there was a rationale to this practice. Now, most of the High Court transfer policies do not really articulate what is the purpose of transfers anymore. So they do not say, for example, that it is so that judges remain impartial. There is no indication what is the purpose of these transfers, especially given that they are fairly regular. They have an annual transfer inter-district sometime in the monsoons, depending on the state. For example, in UP it is sometime in September, October, and their portfolio keeps changing. There is no rationale given for this practice, and we can only assume that it continues to be a colonial hangover, where we have not really thought about what is the purpose that is being served by these transfer practices. The other problem is that there is always commonly, especially the bar is aware of the fact that there are certain districts which are considered to be punishment postings, and there are certain sought after districts where all judges want to be posted at. Now, in some jurisdictions, for example Kenya, which was also formerly colonized by the British, their transfer policies clearly indicate that the litigant has a right to have equal access to competent justice. And this makes sure that at least transfers are not really used as a tool of punishment. since this process is also done very intransparently, we are not sure if this is not being used as a tool for punishment, where judges who are seen as either incompetent are sent to postings which are not very lucrative. And this also compromises the rights of citizens to have access to competent judges, because you will have probably better judges in the state capital and maybe not so much in the districts which are far off from the state capital. Again, the rationale for these policies is not clear, and combined with all the other administrative practices. So think about the unit system that we just spoke about, which is already incentivizing judges to deal with the easier cases fast. Then you have an incentive in the form of you are aware that there will be a successor who will take over your caseload. And you can easily make sure that the complicated, lengthier cases are then transferred to that judge, and you are transferred out to a new district where you will have a new caseload. What these practices are encouraging is that they are making sure that older, lengthier cases are just pushed into the background. And this is really harmful for the efficiency of the legal system as a whole. So when you're designing judicial policy, especially an administrative practice like transfers, you cannot really prioritize. A lot of the people argue that transfers also expose judges to better. So, for example, if you are posted to the state capital, which sees more civil litigation, your career growth will be immense in that period. But perhaps it's not fair to then think about transfers as a policy which is used as a way to mold that judge into a better judge. You need to think about all the stakeholders in the legal system, especially the litigants, and make sure that there are competent judges being selected in the first place. And then you also have a permanent docketing system so that you know that that judge is committed to that particular caseload. So these two administrative practices have to be seen in combination, and the effect that they have is they make sure that complicated and lengthier cases are pushed into the background. Now, we are not really arguing for the fact that these judges should not be subjected to a performance assessment at all. The unit system that is so critical in deciding their career progression and, in fact, their long-term career in terms of compulsory retirement. It's just that right now the way this practice the way the High Court exercises control is it's not transparent. We have seen cases where judges often litigate for certain adverse remarks from their ACRs be expunged or their ratings be corrected. The problem is that only the High Court controls this system. They devise the unit methodology, and there could be other ways of conceptualizing performance assessment. In other jurisdictions, there are ways in which the judges are subjected to bar polls where they get feedback from the litigating lawyers. They also get feedback from their colleagues. And perhaps all these stakeholders should be involved in this performance assessment process rather than concentrating it within the High Court. Now, given that the effect that this is having on the legal system, we have also sensed that there is a loss of legitimacy that this particular, especially the district judiciary currently faces. People they perceive the district judges to be heavily corrupt, and just because of the length of time that it takes to dispose cases and to get justice, there is a sense of the system does not really enjoy public trust. And since we cannot cover the entire book, in the third part of the book, we have given some long-term prescriptions which we think can address this loss of legitimacy that the district judiciary is currently facing. And one of those reforms that we think perhaps is far-fetched but should be tried out in a country like ours would be the institution of trial by jury, especially for crimes. And the jury system, the trial by jury, was in fact practiced in India it was not uniformly practiced. There were certain cities which did have juries, like Calcutta, Bombay. They had a long tradition of juries. But we do think that reintroducing juries in India can perhaps correct this loss of legitimacy that the district judiciary is particularly facing. There are many advantages to juries. The first being that it gets ordinary citizens into the courtroom in a decision-making capacity. Now, this has many advantages because not only does it encourage an appreciation for the rule of law, it also makes sure that the judges and the lawyers are communicating in a manner that they make law palatable to ordinary citizens. The evidence will still be led by a judge, but the jury can participate in the decision-making. This is important for many reasons because perhaps people associate bias with juries, but let's not forget that the individual judges can also come with their own set of biases, and a diverse jury who comes from a diverse set of life experiences will perhaps moderate that bias, has a better chance of moderating that bias than an individual judge. Juries can also offer a check against cynicism. Career judges who have spent long time in the legal system perhaps become slightly more prone to accept the inefficiencies which are in practice, and perhaps a fresh outlook that jurors can bring to the legal system will correct those inefficiencies in different ways. So they can offer great checks against bias and cynicism. Again, given that the district judiciary is so heavily associated with being corrupt, juries are also a double security against judicial corruption, because not only would then you have to approach a judge, you also have to approach and bribe a certain number of jurors. So it becomes more difficult, in fact, to practice corruption in the judiciary in that sense. And there are many other intangible advantages that juries as an institution brings. There are several societies who are now adopting juries in South Korea and in Japan. They were adopted relatively recently in 2008 and 2009 because the societies did not really trust the judiciary to treat the elites fairly. And perhaps we can make the case that we are going through a similar crisis of legitimacy, especially when it comes to trust in the judicial system. And it could be a good way to correct our cynicism about the justice system, where we get to meaningfully participate in the courtroom in a decision-making capacity. Juries were in India, they were in existence till the 1960s, and they were abolished after the Criminal Code of Procedure 1973. So in certain cities, especially like the presidency cities, they were fairly popular. Although when they were in existence, there were very strict eligibility criteria to serve on the jury. They were perhaps restricted to a certain class of people who were propertied and perhaps male. We can, if we want to reintroduce jury, think of better representational safeguards and make sure, given especially that our criminal justice system discriminates against the marginalized communities more, we can have some representational safeguards built into the composition of jury and correct those imbalances in representation. And it could be a good way to make sure that even lawyers and judges start respecting citizens in the courtroom more and make sure that law is understood by everyone. So yes, perhaps now we can entertain. That will be my time. Thank you.
First, I want to say this, that before this lecture, I used to have a very dark view of the district court judges. And I must confess that after listening to you, I think I'll be more sympathetic to their cause. I only used to think that, the only reason for their inefficiency is the burden of cases on them, and there are too many cases they can handle. But now I realize that the difficulties in coping with the kind of difficulties, especially the disciplinary mechanism, I think that I see that in a parallel line when we work with nationalized banks. And they refuse to give credit because they get the salaries, and why do I want to take a risk? I'm very happy with what I'm doing. So no one wants to take a chance. I didn't expect that the judiciary is also an aspect of it. I mean, if there's an overhanging fear of bail, of giving bail, you don't need to find the reason. That fear is there. And the litigant is obviously at a disadvantage. So I must thank you for helping me to change my view 180 degrees from what I thought it was and what it is in reality. Thank you very much for that.
There is one thing which you mentioned about tribunals being created in order to shift the cases from the regular judiciary to specialized judiciary, specialized quasi-judicial tribunal. And the idea was that there should be less of a burden on the High Court and maybe the Supreme Court. But in one or two cases, Supreme Court and High Court have decided, even if it goes to tribunal, that is again appealable again back in the High Court under Article 226 or 32 of the Supreme Court. The whole objective has been lost because the entire thing again, same burden is there in the High Courts. That's one aspect. The second aspect is, I find that in the appointment of tribunals, what is very important is that they should have a specialized knowledge, an expert knowledge in the field. That was the main thing. But the law is so framed that you have done public service and you have done this, that and all, you can get in. That doesn't mean that you have the expertise suddenly developing. You have got to develop it over a period of time. So does it not really mean that the law itself has to be changed, that only experts in that field should come in and they should form the bench? Otherwise, the whole objective is lost. There are two questions I want to pose to you.
Issue of specialized tribunals, I'll start with your second question first. You're right. I mean, the problem is the way the selections are done in India. Even if there are people with specialist qualifications, they're often not appointed. But a larger problem is a lot of these new areas of law, there just aren't enough people with adequate experience in the, in the country. Because when competition law came in, it was such a new field. So initially there was no, we didn't have enough experts, lawyers or, academics who could be appointed. As a result, IAS officers, etc. were being appointed. So that is one problem, but yes, ideally you would want better specialists on these tribunals, and that involves fixing the entire appointment process of for tribunals, which is, we can write another book on that. It's completely broken and it's opaque. On your first question regarding creating tribunals and then bringing it back under the control of the courts, I mean, so there was a unique set of circumstances. This happened, I think, in '97 in the Chandrakumar case, where the Central Administrative Tribunal, the Supreme Court, said that the high courts, you can approach the high courts under their Article 226 jurisdiction. But the reason for that was because the way the government drafted the law, they said you file your case before the CAT, and then after that, your only option for an appeal is you have to file a SLP, a special petition, before the Supreme Court. So the Supreme Court was flooded with litigation. The ideal way to have done it is to have created one layer of an appellate body, because all litigants are given at least two shots, two bites at the apple, right? So they didn't do that, which is why the Supreme Court then had to, it was a reflex reaction because they were getting flooded with SLPs. So which is why the high courts then again had to get back jurisdiction over these tribunals. But not all tribunals are functioning like this. Yes, sir, please.
See, supposing the laws were made, that there will be no appeal from the tribunal to the High Court or Supreme Court. Maybe
even supposing you are able to manage that, at least you can have the objective served. Now, because everything is open now, the entire thing is back to square one.
Yeah. It's true.
You have a wonderful lecture. So, since my childhood, I have been hearing about Constitution of Indian Judicial Services. I just want to know what are the factors that proscribe the formation of the Constitution of Indian Judicial Service.
The book, but I have written some other reports on it which are available online. The problem with the All India Judicial Service now, first of all, is we don't know what problem it's setting out to solve. So, I mean, I think the title of our report also was a solution searching for a problem, because we don't know what exactly this All India Judicial Service is going to solve at all. Because the judiciary has always been, traditionally been a state subject, because only during the emergency it was shifted to the, concurrent list. And it was during the emergency that the idea for the All India Judicial Service came to the Constitution. But there is a lot of opposition from high courts and states, especially in the Northeast, against the idea of AIJS because of concerns of language and concerns of knowledge of local customs and traditions. And language is a very important issue because unlike, say, the IAS and the IPS, which are managerial services, they're dealing basically with other bureaucrats. Judges are, it's a citizen-facing role. Their proficiency in the language has to be near native. You cannot have like these IAS, IPS officers who come and pick up a smattering of the local language. And language is, and law is all about the language at the end of the day. So I personally think it's a terrible idea. Chitrakshi, you want to add?
It also compromises the control that the high courts get to exercise over the district judiciary, because as per the constitution, it has to be the high courts and the state governments who are responsible for the administration of the judiciary under them. So if you centralize these services, that will be compromised, and and therefore the high courts and the state governments have very strongly written against it. Because this idea keeps recurring and entering the public debate every few years. The standing committee had in fact asked the high courts to give in their opinions, and most high courts are against the idea of an all-India judicial service.
And there's also the worry of who will control the appointments and removals of these judges, because we suspect the central government bureaucracy wants to seize this power for itself, and I don't think anyone wants this kind of power centralized with the union government, especially what we've seen over the last 10 years.
I'm Pradeep. The first part of your talk, Tareekh Pe Justice, was, it has opened up a lot of knowledge for us. Okay, but I find that there is the opinions that you have expressed, some of the on the plight of these judges. I think I have a different view. They say that Caesar's wife should be above suspicion, which means that there should be zero tolerance for any wrongdoing, which means there can be an error on the wrong side or on the right side, whichever you say that. There has to be a lot of safety, because of which the judges may get a beating once in a while. I think that should be allowed for keeping the thing of Caesar's wife, keeping in that. Okay.
First of all, we think that every public servant, especially a judge, is entitled to a fair procedure. But this is not, the cases that we are mentioning is not happening on a one-off. So unfortunately, high courts are so opaque, they don't release statistics proactively on how often disciplinary inquiries are happening. So we had to RTI this information. 5 high courts gave us, I think we asked for 15, and maybe 5 high courts gave us some information. Over a span of 5 years, there have been 198 disciplinary inquiries initiated just by 5 high courts. So this is not something that is happening on a one-off. The frequency appears to be quite worrisome, and when you combine this with how the performance assessment system works, where high court judges can enter an adverse entry into the ACR saying integrity doubtful, all of this contributes at the end of the day to a climate of fear. Even it's not our case that corrupt judges should be allowed to go scot-free. We are just saying you better have better investigation and ensure that the disciplinary process is more transparent. For example, why is it now that a high court judge who is accused of corruption in this Justice Verma case, everything is going to happen in the public domain once the impeachment process starts? Why can't we have the same thing happening for disciplinary proceedings before, for the district judiciary? Let the entire process play out in public. We are in a situation now where a judge is dismissed, his review petition before the High Court is dismissed, and they still will not give us a copy of the inquiry committee report. So the idea is, what we are asking for is build a system that is transparent and fair and builds confidence in all the participants, including the judges. And if there is a corrupt judge, go after him. But there has to be a reasonable standard, because the moment you let these standards slip and say that, on a whiff of suspicion, I'm going to start dismissing people, we land up in a situation where we are today, where judges don't want to grant bail at all or decide certain kinds of cases. Which are those 5 high courts? I think Punjab and Haryana, Gujarat, Bombay High Court, 2 more. I'm sorry, I don't remember.
Ma'am, sir, either of you can answer. If transparency and reliable data are the key and heart of meaningful reforms, what practical steps can be taken which are realistic to make judicial statistics more genuinely trustworthy without undermining judicial autonomy?
In part 2 of our book, where we do think that the current way of publishing these statistics, they are not really authenticated by either the E-Committee of the Supreme Court or the NIC or the Department of Justice, which is jointly responsible for the judicial data grid. So the correct way to go about it would be to make sure that they disclose the parameters, first of all revise the parameters on which they are collecting this data, and also make sure that they are attesting to the verifiability of that data, because currently there's a disclaimer on the website which clearly says that these statistics should not substitute for the actual data collected by the courts. So when you are publishing statistics, the first step would be to make sure that you authenticate that data, and the second would be to make sure you're collecting the right data. So currently, not only are cases being overcounted, we don't have a right way of measuring how much time is spent by each judge on a particular category of case. So we don't know, we don't have a proxy for how to measure the complexity of a case, and therefore how much time is required to decide a case. And therefore we don't know what the ideal timeline should be. So the kind of data that is collected, and then the second thing would be to make sure that the way you collect and publish data is authenticated. This can be easily be made. They can be asked to mandatorily do this through a law.
Yeah, just to add to the late Palin Aryapan, when he was an MP in the Rajya Sabha, called the Judicial Statistics Bill, where he had clearly outlined the types of data, etc., that has to be captured. And the backdrop to his bill actually was a discussion in Parliament between Mr. Jaitley and Mr. Sibal, where they were both complaining. Jaitley was the law minister then. Sibal had been, I think, the law minister. They were both complaining that high courts are just refusing to give data. They're invoking some certain constitutional privileges in Article 121, absurd reasons, and saying that it will impinge on our independence if we give this data. So there's also a power issue over there, where high courts don't want to become more transparent. So the only way to mandate this is for Parliament to bring in a law wherein they are mandated to present certain data to statistics to the government or to Parliament every year to ensure that that the data is true and it's done on a regular basis.
The most important point in all the discussions what we are having is to see that the justice is neither delayed nor denied. So whatever you have brought it out about the independence of the judiciary, frankly, it's a lot of enlightenment to us. So it's not always that the justice is delayed and denied for any different reason. It is also because of the independence of the judiciary or the fear and those kind of things. But in many cases, we see it is neither the independence nor the issue of fear, nor that they are corrupt, that the justice is delayed and denied. So there are cases where in the city civil courts and the district courts go on for years, and several adjournments happen. And in the process, the justice is obviously delayed, and none of these reasons are the cause for that. I don't want to name or anything like that. We have a case against an insurance company. It is neither the government or anything like that. Even in this case, even the insurance company is interested to settle the matter quickly. But the case is there. We had a fire accident in 2013. Now we are in 2025. And so the matter has been there in arbitration. Now in the city civil court, it has been there from 2019, last 6 years. It has only been adjournments and adjournments and adjournments. And finally, the case has been heard about a year ago. After so many adjournments, and matter went back to High Court, because we went to High Court and asking them to direct the City Civil Court to hear the matter quickly, and then City Civil Court heard the matter, and then the judge reserved the judgment after hearing the matter. Then he is transferred. He has a motive to transfer him because of this case, or this is a small case, we are two small people, that way. Yeah.
Why do we have these insane transfer policies for judges? Right? Because litigants like you are suffering. Why transfer judges? And if I can give you a certain explanation on why perhaps your case kept getting adjourned, is because of what Chitrakshi explained. The judge is sitting and counting how many units do I need for this quarter to get a rating. Your case may have been a bit complicated, so he's found about 10 other simpler cases and decided, okay, I'll decide these. I'm just going to adjourn this. Neither party lawyer is really pushing it. So I'm just going to keep adjourning it and until I get transferred, which Like, we perfectly explain what happened to your case right now.
But understand, but the case here is that the kind of adjournments, can there be a situation or can there be a law, something like that, you can't accept more than 5, more than 10 adjournments or anything like that?
There's Order 17, Rule 3 of the CPC says not more than 3 adjournments. They introduced this in 99 or 2000.
But nobody follows.
Nobody follows, right? Exactly. That's the problem. And human behavior cannot be regulated just by one rule in the book. You have to look at what the incentives are for individual judges. And that's what we are trying to explain, how the incentive system works out for judges.
And the incentives are for the lawyers, because lawyers also charge a per appearance fee. So we have only looked at one category of legal professionals, but there is litigation culture which also has to be reformed.
I agree, but since you said that not more than 3 adjournments, there is already a law, and if it is not followed, then what is the remedy?
Technically, it depends who's asking for adjournments. So your lawyer technically can move a motion if the other side has asked for 3 adjournments. Asking for the case to be proceeded ex parte. That is, the judge just has to hear arguments without the other side. But if your lawyer moves that motion, the judge accepts it, the other party will file a complaint against the judge. And then we fall back into what we exactly explained right now.
No, but here actually what happened, I'm sorry to extend another 1 minute, actually we filed that, our lawyer, and then the ex parte judgment has been given by the city civil court in our favor. And then the insurance company went to the High Court. Not that they are interested to go, but it's public servants, that they can't accept that. So then the High Court gave a directive, reverted the case back to the city civil court to hear the case again, to give some opportunity to the other side to present themselves. Again, adjournments.
Sorry, our book ends at the district courts. High court is a different problem.
Told that you were a very fair judge. Let me tell you what his fairness is. Every time there is a complicated case, he calls both the petitioner and the defendant's advocates to his chamber and collects equal sums of money from them. On the day of the judgment, after the judgment, he returns the money to the counterparty who lost. I think in corruption, he's been very fair.
One of the most important things, so I have studied from Delhi University. So when I joined Delhi University, I also wanted to be a judge. So there used to be a debate that, यार IAS के लिए बैठना चाहिए या जज के लिए बैठना चाहिए. तो the normal consensus used to be कि जज बनना चाहिए क्योंकि वहाँ पे आप अपने कोर्ट के मालिक होते हो. So let's go with that. But then we had our first criminal law class, and our professor of criminal law happened to be the one who resigned from the office of magisterial court because he had its own issues, most of it which has been discussed by sir and ma'am today. That how in some of the cases there used to be inquiries ordered and then similar kind of things were happening. Having said this, let's come back to day before yesterday. One of my friend who actually bought that area and now serving as a judge in Prayagraj. Now an order of inquiry has been launched against him. For a fact that all of you must be knowing that in civil case, it's not just about when you have decided the case, degree itself will be sufficient, but you'll also have to file for execution. So, and we had a long debate when he joined. We were very excited. I'm from Delhi University. 13 of my batchmates are now serving in different cases, and 4 of them have already resigned after serving for 2-3 years. So one thing which also one should look forward to, one data I wanted, if you guys have collected or not, that how many probationers are not getting confirmed, if you have came through that particular data or not, because that I was not being able to find here and elsewhere also. So this one, yeah, sure. So how can we deal with these kind of things? Because he's saying that it's very disappointing that when I stood up, I ordered execution, ordered bailiffs, that you do it in a particular set of time. My own colleagues are saying that, yaar, law यहाँ पे क्यों लगाना है? ये थोड़ा ज़्यादा पेचीदा मामला है. And also there was a practice which he told me, I don't know, again it's a hearsay, you can consider this, कि files पे लिखा होता था कि जज के रिश्तेदार की फाइल है ये, तो आप थोड़ा इसको ध्यान से देखो. So that was the problem. So how to deal with these kind of things? वो आपके अपने कलीग ही आपको जो है वो डिमोटिवेट करते हैं इस तरीके के केसेस ना लेने के लिए. So yeah, I mean.
Statistics on how many probationers are in fact confirmed into service are not made available, but the selection lists are made available. And then perhaps from the orders which are either discharging them from service or confirming them from service, that can be something that people can do, but ideally it should be the high courts who proactively publish this data, but they do not do it. They make the selection list publicly available, and of course the orders of either confirming them into service or discharging them from service are publicly available for each state.
Yeah, quite frequently, like we discussed. On this, regarding this judges, relatives business, we have heard a lot of anecdotal accounts where, including I think from one retired Karnataka High Court judge has said this on video, where relatives of practicing offspring of serving High Court judges will turn up in district courts and subtly name drop their parents' name, and that then ends up influencing the judge's decision in that case. It may very well be that the judge thinks that, okay, now this is too scary, I just want to decide it and I'll just grant an adjournment. That's the easier route out of there. But what you're saying is, a second order consequence of this entire mess. And reforming this is very difficult because it's you have to tussle with the high courts for their power. And they are not going to give up their power that easily. And if ever we find a political party which, wants to invest in this kind of reform, they have to be ready to lock horns with the judiciary over this power. And the payoff is very, very poor for a political party trying to do this. Because we have seen what judges are doing, suo motu actions here, there, one CBI inquiry. So this is what makes judicial reform, such a difficult issue in India today. And we're not even talking about it, like district courts are not even on the agenda. Thanks to Manthan, we are here to talk about it, but it is not on the reform agenda anywhere.
Because the number of district courts in India, coming up with any sort of uniform reasons for why certain things operate in those certain ways. I was just wondering about the difficulties in coming up for those reasons, in trying to find the uniformity in such a large operation.
Yeah, actually, precisely for this reason, because researching on the judiciary in India is extremely difficult. The high courts have offended the RTI Act to such an extent that we are the worst institutions when it comes to transparency in India right now. So the only option then for us is, for example, for these disciplinary inquiries, we had to read 150 judgments where judges challenged their disciplinary action before a high court or the Supreme Court, and a judgment was delivered. And from those 150 judgments, we mapped this entire issue. And we've had anecdotal conversations with some judges here and there. And even after we published the book, there've been some retired High Court, Supreme Court judges who've been more candid after the book got published, where they've kind of confirmed some of the trends over here. So we're definitely on the right track. But yes, we don't have solid empirical data, because the ideal way to do this would be to conduct a survey of, the judges serving, but they are so scared, they will not talk to you. On the record is out of the question for most of them. Because we have tried earlier when we were working with think tank, we did try talking to certain junior judges because we were looking at the judicial training. And more than once we would hear on the phone that, no sir, I need to ask, district judge sir for permission. And I'm like, you can take away the life and liberty of a citizen, for 3 years, and you're worried about talking to me without getting permission from your superior judge. So it's impossible for us as outsiders to do some of this research. It has to come from within the judiciary.
Although there is an academic who is teaching at the Jindal Law School, Shivraj Huchanavar, who has done some empirical work on the service conditions of judges, and especially on the questions of their internal independence vis-a-vis the disciplinary inquiries. He's also written a paper on the occupational stress that these judges are under. Yeah.
But he could do it because he was teaching at the National Judicial Academy, where judges go for training.
So in a country that's like as diverse as ours, where language, religion, caste and gender and all these factors come to play, how would you ensure that all the jurors are on an equal footing when they enter the jury room? Like, Have you considered that?
We don't want them on an equal footing. We want
of diverse people, and especially vis-a-vis the accused. For example, since we know that the marginalized communities are overrepresented in the criminal justice system, you would have to make sure that the jury corrects that imbalance and is somehow represented also by people of certain identities to make sure that imbalance doesn't play out in the courtroom proceeding. But I'm not as cynical about jurors not taking their responsibilities seriously. I think if we try it out, it might go fairly well.
I used to consider, most of the judiciary above the law. But this talk has highlighted that they actually are victims of that very law and the system thereof. So thank you for, I don't know, I guess I have more empathy for that district judge in, up there who's dealing with my Kutti case, like small case, with more empathy. I kind of understand. So thanks for doing this. I think shining the light, it has to start with this. And at least you have one citizen going back with a bit more warmth in my heart for, this profession and everything else that, you guys are going through. It's really enlightening, actually.
Good evening. I just had a question on the future, an optimistic view or a pessimistic view. So, there's a lot of new stuff that's coming out. Maybe arbitration is more in vogue now. Mediation bill that's come out a couple of years ago. Do you see the people not going to the judiciary as much, like the district judiciary, and bypassing different routes, bypassing judiciary? And are you optimistic about the future, next decade, next 2 decades? How do you look at it?
Just already choosing other alternatives, right? For example, the first advice a lot of lawyers will give their client is, let's file a criminal case in a police station. It's easier to manage the SHO, and the SHO will get this done faster than going to court. The other form that we see where people have decided to bypass courts are encounter killings, where policemen are, killing people in cold blood without a trial. The third form we're seeing is bulldozer injustice, where we're using bulldozers to take care of issues which bureaucrats just don't want to go to courts for. So that crisis of legitimacy has already enveloped the system. The only question is how much lower can we go from here? I think we're close to the bottom. Perhaps I'll be proved wrong. And changing this situation it's very difficult, because this issue is just, when it comes to talking about the judiciary, the High Court and the Supreme Court are the sexy topics. And this is the largest turnout that we have ever gotten for one of our book talks. So thank you all for coming. But otherwise, speaking about district courts and getting a conversation going on reforming district courts is very, very difficult. And we're talking about changing a system that has been in place since about 1875, 1860s. So the inertia in the system is a lot. And just getting that conversation started, reforms are dur ki baat. First, we at least have to start, get that, having that conversation in our circles, in the media, etc., to get that steam going. And traditionally, political parties have stayed away from judicial reform unless it's on the issue of, appointment of Supreme Court, High Court judges, because that's a question of political power. So I'm not very optimistic in the near term.
My question is not related to the topic you just spoke about, but as legal scholars, I think I would love to hear your view on the new legislation that the central government wants to introduce, has brought in actually about the, the automatic disqualification on the 31st day of the tainted netas. So, how do you see, is it fair, unfair? It looks like it's an lofty thing on face of it, but how do you see it?
I think it's really unfair, visions that we've discussed here. So if you have a minister in jail for 30 days, not being granted bail because of a system that is clearly biased, and where High Court judges have certain extrajudicial levers of power, this is an open, it's an open invitation for abuse and undermining elected governments. I'm definitely not in favor of it.
Question was specifically to Chitrakshi ma'am. So you spoke about the issues with the unit assessment system, right? And you kind of proposed how we can have a feedback mechanism. My question was, is it at all possible to have an objective methodology in how we assess judges, even if we take from any other jurisprudence or any other country? Is that at all possible, even as an ideal goal?
We won't, it is possible in the sense to make sure that the stakeholders are properly represented, because currently what is happening is that it's only based on the assessment of one supervising judge, which is perhaps not fair to the judge who is being assessed. So if we make sure that the bar is involved and their peers are also involved, we at least the abuse in terms of the subjective assessment will go away. Of course, it is also hypocritical because the higher courts are not subjected to any performance reviews. So we can perhaps start from there. I mean, there is no equal footing there. It's only the district judiciary which has a performance review in place anyway. So,
yeah, and also I think the question is, what are you using the performance assessment for? We are very against this idea of giving more carrots to the judge for, for a promotion or for a better posting. So the idea of a performance assessment in the judicial context should be for the judge to improve himself. Because they're sitting on the bench, they're just used to people deferring to them all the time. There's no feedback loop on how they can be wrong and terrible, that the behavior can be terrible on the bench. So an anonymous feedback loop from the bar and, court staff can help a lot in trying to fix some of these issues. It's more of character improvement than accountability.
So getting that post?
Get a post. So this is the comedy of the Indian legal system, right? Every lawyer, every judge will complain the system is corrupt. You ask them, have you ever paid a bribe, received a bribe? They'll say, I've never paid a bribe, never received a bribe.
Another thing is, some judges are branding for the granting bail, some are not. Thus, what is the role of the merit of the case? Have you comment on this?
I'm sorry, I didn't understand.
So some judges are branding for granting bail, some are not. If the case goes to the XY judge, you will definitely get bail. Otherwise, some people are branding for not, they will not give the bail. So where is the merit of the case? I don't understand actually.
Yeah, I mean, that's a problem, right? Because of some of the issues that we've discussed here. Some judges are more afraid of granting bail because they're worried of an inquiry. Maybe some judges are corrupt. I'm not discounting that. That's completely possible. But it's impossible to give like a single answer to your question. There'll be 1,000 different reasons.
My name is K.S. Ramakrishna. I just completed my LLB first year, 3 years course. I have very limited knowledge about the judiciary systems. And the other part, thanks for the organizer for giving me an opportunity to come out my feelings a little doubt. I have been visiting the Secunderabad court from the past 3 days. Though I have very much little knowledge about the judiciary, but I have already completed my 56 years of age. So I have seen today and yesterday there is a gender discrimination and age discrimination. When an advocate who is the age of 60 years and speaking with the judge who is a female of 35 years, the way of cross-examination and the way of he is indirectly exploiting the judge is I have seen. So is there any, but I asked one of the judge, is there any prescribed communication rules? I asked, he told, according to my knowledge, he is there only 50 years. He told, in the High Court and the Supreme Court, we have a certain kind of guidelines. But here, ye pura chalte rehta. Did, honorably I am asking, if I heard you both, did you people cover this kind of things in your book?
No problem at all. I mean, see, on this age issue, regarding the age issue of, on like conduct of people in the courtroom, etc., the power equations are just different in the district court and in the high courts. Because in the high courts, the lawyers are a little bit worried about the judge. In the district court, the judges are more worried about the lawyers, where the lawyers will go complain. So the power equations are very different. And even on the age issue of, like a 35-year-old being on the bench, etc., we've covered that in the book, where we think that people are appointed as judges at too young an age in India. Like in other countries, judges with a practice have practiced for at least, say, 20-25 years before they're appointed even as a magistrate. In India, the practice requirement is only 3 years. And that has been reinstituted only now. Before, you could just directly graduate from law school and become a judge at the age of 21, which has happened, where the levels of maturity, emotional maturity, professional maturity are very, very different. So there are a whole bunch of answers to your questions, but I think these are the main reasons for the kind of difference in conduct that you've been observing.
Sir, I was a judge few months back.
Oh.
I resigned. And my question basically, it's not more of a question, it's an observation. I read your book and the starting few pages which come regarding the rules which apply on judges. Like the same rules which apply on a bureaucrat apply on judges. The role of judges is a completely different mechanism. There is always going to be an aggrieved party, irrespective of what you do. There is always going to be a party who is unhappy with an order. So there is always a chances of complaint. That's how you started your book with.
Yeah.
And all the way till jury. I do not completely agree with your jury stance.
Nobody agrees with us.
Nobody agrees with it because, of course, after Nanavati case, 8:1, nobody is actually holding that in the current scenario. Maybe in future, hopefully, and especially when the scientific knowledge comes into picture. The concept of unit system, like I've been doing it day in, day out. Unit system is a point of assessment which comes only to aid the number of filing, which on the judicial data grid there will be different numbers which are updated. The same case will have 100 petitions filed, even they are updated. But every month the judicial officer sends a statement to the district court, which is then forwarded to the High Court and then goes to the Supreme Court committee. So a district court officer actually analyzes how many criminal petitions are filed, how many IAs are filed, how many miscellaneous petitions are filed, how many are decided out of that, and after how many are decided, a unit assessment is made. And not every assessment has a unit, only something which is going to have right affected of a party, like Order 7, Rule 11. A party who has filed a case, his entire case goes away. No, that is a big order, an injunction application. Somebody's liberty is curtailed. Now, these are the concepts which are there in civil side. But in criminal side, there are no units like what you are telling, 1 unit, half unit. Rather, it's incentivized. If you deal the old case, you get 2 units. If you deal a new case, you get 1 unit. So the concept is more of disposing the old cases right now.
But it's not uniform across states. Which
is in this state.
But it's not uniform across states.
Yeah, it's not uniform
states
across.
Which have different.
Exactly, but I know about this state and I have my batchmates all across.
Yeah.
So the concept with respect to ACR, it's 2 ways. There is a quantitative assessment and qualitative assessment. The qualitative assessment is when we every month send a judgment which we have written to the High Court. The High Court, after 12 judgments which it has, it analyzes those judgments with respect to application of law, appreciation of evidence, appreciation of facts, marshalling of facts. These are the criteria which has been there since time immemorial. And this is what the British has also laid down. Even if you read any treatise on civil adjudication, this is what it lays down. So the same parameters we have. How do we marshal a fact? What are the possibilities? Whether the circumstantial evidence is examined properly. Whether the conviction is based on this.
How fair are High Court judges when they're doing this assessment?
Sir, they're fair. As I know my reports. Can't comment on others. So they're fair. But when these assessments are made, it is not just the High Court judges who make an assessment. Even the district judge assesses it. Then it goes to the High Court for second assessment, and then it portfolio. And after the portfolio, it goes to the committee. So the entire assessment is qualitative and quantitative. So once your qualitative is high and quantitative is low, still you get a very good. Once your quantitative is low and qualitative is low, then you get poor. So there is a balance which the system is trying to make internally as to, okay, there is pendency, multiple stakeholders are involved in pendency, not just the courts. The advocates want time because they delayed the cases, the more adjournments, the more fees. Similarly, police will not bring the witness just because there is going to be an apprehension that he will turn hostile. Similarly, public prosecutors are not there in half of the courts that you see.
Yeah.
So when you see all these assessments out there, it's not just the case is being heard by the judge. It's also because you can just now go to any court right now. The public prosecutor comes only on Monday and Tuesday, but the pendency is 7,000 criminal cases. So on one day and on 2 days, how many cases can the judge hear? So all these contributing factors also affect the performance, which even the high courts and the district court and the trial courts are also very mindful. that, okay, that court does not have a public prosecutor, he is not able to attain so-and-so units. So every year when our ACR is sent, there is a line which says that no permanent public prosecutor assigned to this court. And then it passes on. That year is not assessed. That entire year is not assessed in the entire aspect of assessment. So the unit system in a way is both incentivizing. At the same time, it does create pressure when you have a lot of cases and you have a lot of High Court directions and you have a lot of Supreme Court directions. And at the same time, if you understand the life of a magistrate or a judge, like he sits at 10 o'clock and he gets up at 2 o'clock. That's the time. 2 to 2:30 is his lunch. Again, he sits at 2 to 6 he sits.
Most of them don't sit after lunch.
Yeah, exactly. That's a complete sitting job all day long. So if you see the medical assessment of what the judicial officers have across, now most of them have lumbar spondylitis, they have a brain. I did not know before I joined judiciary and after I resigned when I speak to them, that there is a blood pressure in the brain too. And all the judicial officers have that blood pressure or the secondary post-traumatic
all that blood pressure is coming from where? Because of High Court judges.
I would know, sir. It's coming from everywhere. It's the lifestyle that comes with it. So at 10:30, 7 o'clock, you come home. And after 7 o'clock, you eat your dinner. You have half an hour with your family. You sit on the next day's judgments. At 9 o'clock, the police comes with a remand. At 1 a.m. in the morning, you have to go to hospital.
I'm sure you must have been an outstanding judge. So
Yeah.
trust me, I know of a lot of judicial magistrates who are not working this hard.
Thank you everyone.
Thank you.
If everyone is telling a story, I will tell you one more story.
Please.
My fascination for district courts happened because in 1994, my computer was stolen in my foundation. And I'd filed a case in the police station because for insurance you have to file a case. In 2016, a police officer came to my house issuing a non-bailable warrant, saying that is a clear 20 years later. And I then panicked and then I discovered that it is because I had not appeared for this court case, whatever it was. And so next day I appeared in the court. I enjoyed that situation. That since then I've been fascinated by what you wrote today. I appear before the magistrate and then the public prosecutor comes and tells me, what is the computer you have lost? And then thanks to my elephant memory, I remembered the name. I said it's Busy Bee. He said, Your Honor, it is wrong. The name of the computer is Intel Inside. So I asked the magistrate that, can I explain this problem? Then he said, yeah, for a change, he said, Chapandi. Then I said, suppose you buy a car, and the car is, let's say, a Maruti car in those days. And then the tire is Firestone. Intel Inside is Firestone, car is Maruti. Then the magistrate commended me, saying, for my superior knowledge of computers, and discharged me. So since then I've been fascinated by what do these magistrates know, more important, what do these public prosecutors know. I've got a non-bailable warrant for an offense which I complained. So, and I think your book captures some of these issues very, very well, and I must congratulate you for that. Thank you very much for being with Manthan.